My son-in-law called me just the gardener in my own backyard, but weeks later, he walked into a courtroom and realized I was the judge deciding his future. Hello, everyone. Before we start, join our YouTube family by subscribing to the channel. Don't forget to like this video and tell me in the comments where you're watching from and what time it is. Now let's get into the story. The first time my son-in-law called me just the gardener, the sun was high, the grill was smoking, and laughter floated through the backyard like it belonged there more than I did. It was a Saturday afternoon barbecue at my home, the same house I had paid off 22 years ago, the same lawn I had planted tree by tree with my own hands. I was trimming the hedges near the fence, wearing an old faded shirt, gardening gloves, and a wide-brimmed hat to keep the sun out of my eyes. I've always loved working with soil. It reminds you that growth takes patience. That silence builds strength beneath the surface. Daniel, my son-in-law, stood by the grill in a pressed polo shirt and expensive watch, flipping burgers like he was hosting a corporate networking event instead of a family gathering. He liked audiences. He liked status. "Hey," he called out loudly, gesturing toward me with the tongs. "Can someone tell the gardener we're running low on drinks?" A few of his colleagues laughed. My daughter stiffened slightly beside him, but she forced a smile. The word hung in the air heavier than the smoke from the grill. The gardener, not Dad, not my name, not even my father-in-law, just the gardener. I paused for a brief moment, then removed my gloves calmly. I walked toward the house without saying a word, retrieved more drinks from the refrigerator, and returned to hand them out. Daniel didn't even look embarrassed. He assumed correctness. That's the thing about arrogance. It rarely questions itself. One of his coworkers leaned toward him and whispered, loud enough for me to hear, "Good help is hard to find." Daniel chuckled. "Yeah, but this one's reliable." I smiled faintly, not because it was funny, but because it was revealing. Daniel had married my daughter 3 years earlier. He worked in corporate finance and carried himself like someone who believed titles defined identity. He spoke about net worth the way others speak about weather. To him, visible success was the only success that counted. What he didn't know, what he never cared to ask, was that I preferred simple clothes on weekends, that I found peace in trimming hedges, that after decades in law, I valued quiet over recognition. He had never asked what I did for a living. He had never shown curiosity beyond what he could see, and I never corrected him. Because I have learned something in my career. When someone reveals how they see you, believe them. Don't interrupt. Don't defend. Observe. Daniel thought I was beneath him. But status built on assumption is fragile, and life has a way of arranging meetings in unexpected places, places where titles are not guessed. They are declared. Daniel's opinion of me didn't form overnight. It grew slowly, built from assumptions he never bothered to question. In his world, appearances told the whole story. Expensive suits meant success. Manual work meant limitation. And quiet people, especially older ones, were simply background characters. After the barbecue, the nickname stuck. Whenever he visited, he greeted me casually with,
"How's the garden coming along?"
never asking about anything beyond the lawn, the trees, or the weather. I answered politely every time. Not once did I correct him. Not because I was afraid, but because correction without curiosity rarely changes perception. My daughter Emma noticed it more than anyone. One evening, while helping me water the roses, she sighed heavily. "Dad, you know he thinks you're actually a gardener, right?" "I'm a gardener," I replied calmly, adjusting the hose. She shook her head. "You know what I mean." Of course I did. Daniel had built an entire image of me without evidence. To him, my modest car, simple clothing, and quiet lifestyle confirmed his assumption. He never saw me leave early in the mornings wearing formal attire, because his visits were always weekends. He never noticed the legal journals in my study because he never entered that room. He never asked questions that might challenge his conclusions. "Should I tell him?" Emma asked softly. I turned off the water and looked at the garden bed stretching across the yard. Each plant had taken years to mature. Some needed pruning. Others needed patience. "No," I said gently. "People reveal more when they believe no one is correcting them." Emma frowned. "But it's disrespectful." "Disrespect often comes from ignorance, not cruelty," I replied. "Let him learn naturally." Still, I could see the worry in her eyes. Daniel's confidence had begun to border on arrogance even within their marriage. He spoke about promotions constantly, compared salaries with friends, and evaluated people by professional rank. At dinner gatherings, he dominated conversations. "You know," he said one night while scrolling through his phone, "success is really about ambition. Some people just settle for simple lives." He glanced toward me as he said it, not maliciously, just carelessly. I smiled and continued eating. Years on the bench had trained me to listen without reacting. Courtrooms teach patience better than any philosophy book ever could. You learn that silence often encourages truth to expose itself fully. Daniel mistook my calmness for simplicity. A week later, during another visit, one of his colleagues asked me directly, "So how long have you been doing landscaping?" Daniel answered before I could speak. "Oh, forever," he said confidently. He loves working outdoors. I nodded slightly. "I do," I replied, and that was true. What wasn't spoken was that during weekdays I presided over complex legal disputes, corporate litigation, and criminal trials that shaped lives permanently. My courtroom required discipline, neutrality, and authority, qualities invisible beneath gardening gloves. Daniel never imagined that the man he casually dismissed spent weekdays deciding cases involving executives far more powerful than him. But assumptions have expiration dates, and soon, circumstances would place us in a setting where introductions were no longer optional, and appearances carried no authority at all. 6 months passed after that summer barbecue, and life settled into its usual rhythm. My weekdays belonged to the courthouse, early mornings, case reviews, legal arguments, and long hours spent weighing facts against law. Weekends belonged to silence, soil, and the steady comfort of routine. Daniel remained confidently unaware of the difference. Then one Monday morning, everything changed. I arrived at chambers just before 8, greeted the clerk, and collected the new case files waiting neatly on my desk. Most mornings followed the same pattern. Review schedules, examine motions, prepare notes before hearings began. I opened the top folder absent-mindedly, expecting another routine financial dispute. The title stopped me cold: State versus Daniel Mercer. For a moment, I simply stared at the name, convinced it had to be coincidence. Mercer was not uncommon, but as I flipped the page, the photograph removed all doubt. It was my son-in-law. The charges were serious: corporate fraud, financial misrepresentation, and embezzlement involving investor funds from his firm. The allegations described manipulated accounts, hidden transfers, and false reporting designed to inflate company performance, while diverting money through layered transactions. I leaned back slowly, absorbing the information. Years on the bench had trained me to separate emotion from responsibility. But this was different. This was family intersecting with duty. I continued reading carefully, forcing myself into professional focus. Evidence summaries included emails, banking trails, internal audits, and witness statements from colleagues. The prosecution's case appeared methodical and well-supported. My first obligation was clear: disclose potential conflict immediately. I contacted the chief judge and explained the relationship in full transparency. Ethics rules demanded neutrality above all else. Within an hour, a review panel evaluated whether reassignment was necessary. The complication emerged quickly. Emma and Daniel had filed for legal separation. 2 weeks earlier, I hadn't known. That realization struck deeper than the case itself. My daughter had carried that burden alone, choosing not to worry me. I wondered how long their marriage had been struggling while I remained unaware, peacefully tending my garden on weekends. By afternoon, the ethics committee issued its decision. Because the separation legally distanced the familial connection, and no financial or personal interest tied me to the outcome, I could remain on the case, provided all proceedings stayed fully transparent. Professionally, it made sense. Personally, it felt heavy. I closed the file and stared out the office window overlooking the courthouse steps. People moved below, lawyers rushing, citizens waiting, lives intersecting with justice every minute. Daniel had spent years assuming he understood hierarchy, power, and status. Now he stood accused in a system where appearances meant nothing and evidence meant everything. I wondered if he had any idea which courtroom his case had been assigned to. Probably not. In court, names are scheduled long before faces meet. I placed the file neatly back on my desk, adjusting it with deliberate calm. On the garden path, Daniel had seen me as ordinary. Soon he would see me where identity could not be guessed, only recognized. And when that moment arrived, neither of us would be able to pretend introductions had never been necessary. The morning of the hearing arrived quietly, almost deceptively calm. I followed my usual routine: early coffee, a brief review of the case file, and a moment of stillness before leaving for court. Years of experience had taught me that emotional preparation mattered as much as legal preparation. When I entered the courthouse, everything felt familiar. The echo of footsteps in marble hallways, the low murmur of attorneys reviewing notes, the steady rhythm of procedure. Inside chambers, I put on my judicial robe, its weight settling over my shoulders like responsibility itself. In that moment, personal history disappeared. Only the law remained. The courtroom filled gradually. Lawyers arranged documents. The clerk prepared the docket, and spectators whispered quietly from the benches. Then the doors opened. Daniel walked in beside his attorney, confident at first, scanning the room casually, until his eyes reached the bench. He froze. Confusion struck first, followed instantly by recognition. The color drained from his face as realization replaced certainty. His steps slowed, and for the first time since I had known him, Daniel looked completely unsure of himself. "You," he whispered under his breath. I maintained a neutral expression as I took my seat. "All rise," the clerk announced. The room stood. Silence settled. When everyone sat again, I looked directly ahead, not at him as family, but as a defendant before the court. "Court is now in session," I said calmly. The words carried authority he had never associated with me before. In that moment, the image he had built, the quiet gardener, the simple man in worn clothes, disappeared entirely. Now he understood. The man he had underestimated wasn't standing in the yard anymore. He was presiding over the courtroom. The courtroom remained silent for several seconds after proceedings began, but the tension was unmistakable. Daniel avoided looking directly at me, keeping his eyes fixed on the table in front of him as if the polished wood might offer protection. His attorney, however, quickly recovered from the initial shock and stood to address the court. "Your Honor," he began carefully, "the defense respectfully requests a moment to discuss a potential conflict of interest." His tone was professional, but urgency hid beneath it. He had clearly noticed Daniel's reaction and understood something significant was unfolding. "You may proceed," I replied evenly. The attorney cleared his throat. "It has come to our attention that Your Honor may have a prior personal connection to the defendant." Every eye in the courtroom shifted toward the bench. Moments like this demanded precision, not emotion, not defensiveness, procedure. "That matter has already been reviewed by the Judicial Ethics Committee," I stated calmly. "Full disclosure was made prior to today's hearing. The court has determined no legal conflict exists. This case will proceed." The attorney hesitated but nodded. He understood the implication. The decision had already been examined at a higher level. Daniel finally looked up at me, disbelief written across his face. The confidence he once carried at family gatherings was gone, replaced by uncertainty. For the first time, he was seeing me in an environment where authority wasn't assumed. It was institutional. The prosecution began outlining the charges. Financial records appeared on screens. Charts displayed transaction patterns. Dates, transfers, and account numbers formed a clear narrative of alleged misconduct. As testimony started, Daniel shifted repeatedly in his chair, his composure cracked with each piece of evidence introduced. I watched carefully, not as a father-in-law, but as a judge trained to observe behavior without judgment. Years on the bench teach you to separate identity from action. During a short recess, Daniel's attorney requested a private conference in chambers. Protocol allowed it, provided both legal teams were present. Inside chambers, Daniel stood stiffly, unable to meet my eyes at first. "I didn't know," he finally said quietly. "I swear. I didn't know you were a judge." His voice lacked the arrogance I once heard in my backyard. Now there was only embarrassment and fear. "You never asked," I replied calmly. He exhaled slowly, realization settling heavily over him. "I thought," he began, then stopped. "What did you think?" I asked. He hesitated before answering. "I thought you were just ordinary." I nodded slightly. "Court does not measure people by assumptions," I said evenly. "Only by evidence." The attorney signaled readiness to resume. The moment ended quickly, professionalism reclaiming the space. As we returned to the courtroom, Daniel walked differently, slower, humbled by a truth he could no longer ignore. The man he once dismissed now represented the very system deciding his future. The trial moved forward with steady precision, each hour peeling away layers Daniel had carefully built around himself. Courtrooms operate on rhythm, testimony, objection, ruling, continuation, and once that rhythm begins, personal feelings have no place inside it. The prosecution called its first expert witness, a forensic accountant. Calm, methodical, and unemotional, she explained complex financial trails in language the jury could understand. Screens displayed timelines of transactions, money transferred through subsidiary accounts, redirected into private holdings, then masked through delayed reporting. Numbers do not carry emotion, but they carry truth. Daniel sat rigidly beside his attorney, hands clasped tightly together. The confident man who once evaluated people by their income now faced evaluation himself, not by opinion, but by documented evidence. Can you explain the pattern observed? The prosecutor asked. Yes, the witness replied. The transfers suggest intentional structuring, designed to avoid internal detection while maintaining outward financial stability. Intentional. The word echoed quietly through the courtroom. Daniel's attorney objected several times, challenging interpretation, questioning methodology, attempting to introduce doubt. Some objections were sustained, others overruled. Procedure remained balanced exactly as it should be. I delivered rulings calmly, my tone consistent, my expression neutral. Years of judicial discipline allowed no deviation. Inside, however, I recognized the gravity of what was unfolding, not as family drama, but as consequence. During lunch recess, I remained in chambers reviewing notes while the hallway buzzed with speculation. High-profile financial cases often attracted attention, and whispers traveled quickly among reporters waiting outside. A soft knock sounded at the door. My clerk entered. The defendant has requested permission to address the court. Later during proceedings, Your Honor, I nodded. Noted. We'll consider it at the appropriate stage. When court resumed, the prosecution introduced email correspondence. Messages appeared on the screen, professional language masking questionable intent. Phrases about temporary adjustments and short-term reallocations painted a picture of decisions made gradually, perhaps believing consequences would never arrive. Daniel stared at the screen, jaw tight. For the first time, I noticed something beyond fear in his expression. Regret? Not the regret of being caught, but the realization of misjudgment, the same kind of misjudgment he once made about me. The defense presented its argument later that afternoon, framing Daniel as pressured by corporate expectations, suggesting systemic problems rather than individual wrongdoing. It was a reasonable strategy. Responsibility in financial systems is rarely simple. Still, evidence carries weight beyond explanation. As proceedings paused for the day, I announced calmly, "Court will reconvene tomorrow at 9 a.m. The gavel struck lightly. Daniel stood slowly as deputies guided him toward the exit. Before leaving, he glanced briefly toward the bench, not with arrogance. Not with resentment, but with something quieter, understanding. The illusion he had lived by, that status protected people, was dissolving. In this room, titles outside the courtroom meant nothing. Here, accountability was the only identity that mattered. The second day of trial carried a heavier atmosphere. Word had spread quickly through legal circles, and the courtroom filled earlier than usual. Observers sat quietly, sensing that the case had reached a turning point. Daniel looked exhausted when he entered. The sharp confidence he once wore like armor had faded, replaced by someone confronting consequences in real time. He no longer scanned the room with superiority. Instead, his focus stayed low, thoughtful. The defense called Daniel to testify. He walked to the stand slowly, took the oath, and sat down. For a brief moment, our eyes met, not as family, but within the boundaries of law. I gave no expression, offering only neutrality. His attorney began gently. "Mr. Mercer, did you intend to steal funds from your company?" Daniel swallowed before answering. "No, I believed I was fixing temporary losses. Buying time." The courtroom remained silent. He explained pressure from executives, expectations to maintain growth, fear of failure. Step by step, small decisions turned into larger ones. Adjustments became concealments. What began as justification slowly became deception. Under cross-examination, the prosecutor asked carefully structured questions. "You understood company policy regarding financial reporting?"
Yes.
"And you knowingly bypassed those policies?" A pause.
Yes.
Honesty settled heavily over the room. It wasn't dramatic. It wasn't emotional, just undeniable. As testimony continued, I noticed Daniel speaking differently than I'd ever heard before. Without arrogance, without performance. He wasn't trying to impress anyone anymore. He was simply telling the truth. When questioning ended, he hesitated before stepping down. "Your Honor," he said quietly. His attorney looked surprised, but I nodded for him to proceed briefly. "I spent years judging people by what I saw on the surface," Daniel admitted. "I thought success made someone important. I thought simple meant small." The courtroom listened closely. I was wrong. The statement wasn't directed only at the jury. We both understood that. I responded only with procedure. "The jury will consider statements relevant to the case." He nodded and returned to his seat. The trial moved forward, but something fundamental had shifted. Daniel was no longer defending an image of himself. He was confronting reality. And sometimes, accountability begins not with punishment, but with recognition. By the third day, the courtroom felt quieter. As if everyone understood the outcome was approaching, the evidence had been presented, witnesses heard, and arguments carefully laid before the jury. Now the trial moved toward its final stage, closing statements. The prosecution spoke first, methodical and precise. They walked the jury through timelines, financial records, and Daniel's own testimony. Their argument was simple. Knowledge plus action equals responsibility. They emphasized trust, how investors relied on honesty, and how deliberate decisions broke that trust. The defense followed with a different tone. Daniel's attorney acknowledged mistakes but argued intention mattered. He described pressure within corporate environments, unrealistic expectations, and a man who convinced himself he was protecting his company rather than harming it. Poor judgment, the attorney said, is not always criminal intent. The jury listened carefully, faces unreadable. As both sides finished, the weight of decision shifted away from the courtroom and into the jury's hands. I instructed them clearly on the law, definitions, standards of proof, and their responsibility to evaluate evidence without emotion or sympathy. Your verdict must be based solely on facts presented and the law as explained, I said evenly. They nodded and left to deliberate. The courtroom slowly emptied. Lawyers packed files, reporters whispered near the exit, and deputies maintained quiet order. Daniel remained seated, staring ahead as if trying to process how quickly life could change. After nearly 4 hours, the jury returned. Everyone stood as they entered. The foreperson held the verdict form with steady hands. Silence stretched across the room, thick enough to feel. "Have you reached a verdict?" I asked. "We have, Your Honor." Daniel's shoulders tightened slightly. The clerk read aloud each count. One by one, the jury found him guilty of financial fraud and related charges. The words echoed sharply, final and unavoidable. Daniel closed his eyes briefly but did not react otherwise. No anger, no protest, only acceptance. Justice is rarely loud. Often it arrives quietly, carried by evidence rather than emotion. I thanked the jury for their service and scheduled sentencing for a later date. The gavel struck softly, signaling the end of trial. As deputies approached Daniel, he glanced toward the bench again. This time there was no shock in his expression, only understanding. The illusion of status had faded completely. All that remained now was accountability, and whatever came after it. Sentencing day arrived 2 weeks later, carrying a different kind of silence. Trials are filled with arguments and tension, but sentencing holds reflection. By then, facts are no longer debated. Only consequences remain. The courtroom was less crowded than before. Reporters sat quietly in the back rows, and a few observers watched with restrained curiosity. Daniel entered wearing a plain suit, noticeably different from the confident man who once hosted loud barbecues in my backyard. His posture was straighter now, but humility had replaced pride. Before sentencing, procedure allowed the defendant to speak. Daniel stood slowly. His hands trembled slightly as he approached the microphone. He took a breath, scanning the room before his eyes briefly met mine. "I spent most of my life believing success meant being above others," he began. His voice was steady but softer than I'd ever heard it. "I measured people by money, titles, and appearances." The courtroom remained still. "I hurt people financially," he continued. "But I also hurt people personally, especially those I failed to respect when I should have listened." He paused, choosing his words carefully. "I judged a man without knowing him. I assumed his value based on what I saw, not who he was. No names were spoken, but everyone understood. I take responsibility for my actions," he finished quietly, "and I accept whatever decision this court makes." He returned to his seat, shoulders lighter, as if honesty itself carried relief. I reviewed the sentencing guidelines once more. Statutory ranges, mitigating factors, cooperation during trial, and absence of prior offenses. Justice requires balance, accountability without cruelty, fairness without favoritism. When I spoke, my tone remained calm and measured. "The court recognizes the seriousness of financial crimes," I said. "Trust forms the foundation of professional and social systems. When that trust is broken, consequences must follow." Daniel listened without looking away. "However," I continued, "the court also considers acceptance of responsibility and demonstrated remorse." The sentence delivered was firm but lawful. Structured incarceration followed by supervised release and financial restitution obligations. The gavel sounded softly. As deputies approached, Daniel nodded once toward the bench, not pleading, not angry, grateful perhaps, not for the outcome but for fairness. And in that moment I realized something important. The lesson had never been about authority. It had been about understanding respect. Before life forces you to learn it the hard way. Several weeks after sentencing, life slowly returned to its ordinary rhythm. Court schedules continued. New cases replaced old ones, and the steady flow of justice moved forward without pause. Yet something within me felt quieter, not heavier, just reflective. One Saturday morning, I stood once again in my garden. The air was cool, sunlight filtering through the trees as I trimmed the same hedges Daniel had once joked about. Birds moved between branches, and the familiar scent of soil grounded me in a way the courtroom never could. Gardening had always been my balance. In court, decisions ended chapters of people's lives. In the garden, growth reminded me that endings could also lead to renewal. Emma visited later that afternoon. She walked slowly across the lawn, watching me work. "He wrote to me," she said gently. I set down my tools. "How is he?" "He's different," she replied. "He said the trial forced him to see himself clearly for the first time." I nodded. "Change rarely begins comfortably." She hesitated before adding, "He also said he finally understands why you never corrected him." I smiled faintly. Some lessons lose power when explained too early. Experience teaches what words cannot. A few days later, a letter arrived addressed to me. Inside was a short, handwritten note from Daniel. "I used to think respect came from success. Now I know it comes from character. Thank you for being fair when you had every reason not to be." I folded the letter carefully and placed it in my desk drawer. Not as a trophy, but as closure. That evening, I locked the garden gate and looked back at the house. Peaceful under the setting sun. Titles, robes, and authority belonged to the courthouse. Here I was simply a man tending what he had built over time. Daniel once believed I was just the gardener. In truth, both roles had always been part of me. A judge maintains order. A gardener nurtures growth. And sometimes, life arranges circumstances so a person learns the difference between status and wisdom, not through humiliation, but through justice delivered with dignity. As the wind moved gently through the trees, I returned to my work. Content in the quiet understanding that true authority never needs to announce itself. It simply waits to be recognized.